My name is Alina Das. I'm a professor here at the law school and very proud to be the faculty director of the Latino Rights Scholars Program. And on behalf of that program, I just wanted to thank you all for coming to our annual Latinos in the Law lecture featuring the very amazing Judge Jenny Rivera, who we are going to claim as our own as an alumna of this law school. And she has been so generous with her time, and we're particularly excited to be hearing her remarks today. She's going to be introduced by two of our Latino rights scholars. And so I just wanted to say a brief word about the program. So this program brings together individuals who are interested in coming to the law school, to being part of the legal profession, who are dedicated to working in Latino communities. It is a program that provides full scholarships to 2 students each year, and its alumni and alumni who are in the audience today are incredible testaments to this mission. They work at incredible organizations doing the work every day, and if I could ask any of the alums who are with us and the current scholars to stand, that would be great. Thank you. I hope that you will reach out to them and talk to them about this program and consider supporting this program going forward so we continue to further its mission by allowing amazing people to come to our law school and do this great work. So two of the people who are going to be introducing the judge, who are incredible examples of what this program has to offer, are our 2 3L scholars, Francis Davila and Alicia Nieves. They both, from the last 3 years, I've had the pleasure of seeing the incredible work that they have done. Because I sat on the committee that selected them, I also know the incredible work they did before they came here. And they've shown a dedication throughout their lives to working with Latino communities. Alicia here at the law school has inspired me by her passion for really taking the law and technology and thinking about new ways that we can deliver legal services. I know that she is going to really change the face of the way we're able to contribute and help low-income communities of color, and I've just been so impressed by her work. And Frances, I've gotten to know quite well. She's a student in the clinic that I teach, fighting every day for immigrants who are detained, who are facing deportation, and doing incredible work, which she's going to dedicate her career to. So the fact that these 2 are such inspiring Latinas, I think speaks so highly of how amazing it is that we are so incredibly inspired by our speaker today, Judge Rivera, and they're going to introduce her. And before I turn it over to them, I also wanted to just thank LALSA for its incredible support of this program and for all of the work that they've done. We worked together earlier this year on a fabulous symposia, and we look forward to a wonderful relationship working on these issues together. So with that, I'm going to turn it over to Alicia and Francis.
Judge Rivera has spent her entire professional career in public service. She clerked for the Honorable Sonia Sotomayor on the Southern District of New York and also clerked in the Second Circuit Court of Appeals as the pro se law clerk. She worked for the Legal Aid Society's Homeless Family Rights Project and the Puerto Rican Legal Defense and Education Fund, now Latino Justice. And she was recently appointed as a judge by our Governor Andrew Cuomo to serve on the New York Court of Appeals.
On January 15, 2013, Governor Andrew Cuomo nominated her to the Court of Appeals, and the New York State Senate confirmed her appointment on February 11, 2013. Judge Rivera graduated from Princeton University and received her JD from NYU and her LLM from Columbia University School of Law. She was a Root Tilden current scholar and an active member of LALSA while she was a student here. And as a personal note, Francis and I were reflecting on how excited we were to have Judge Rivera here. I come from Indiana, so it's quite far from New York, but I've been really so happy to meet in my legal career in these past 3 years, meet wonderful Latinas in the legal community. And Judge Rivera was one of the ones that I have a memorable moment seeing you in Washington, D.C. You were speaking with the Hispanic National Bar Foundation, speaking with some law student, or rather high school students who are interested in law. And it was just a moment where I think I was reflecting with Francis how wonderful it is to meet these amazing Latinos that are building a strong community inside the legal profession. And so I'm really excited to be a part of that and grow that community for others too. Thank you.
So without further ado, please welcome Judge Jenny Rivera.
Thank you so much for that. Thank you again for that very nice introduction. Thank you to the Latino Rights Scholars Program and the Public Interest Law Center inviting me to present this year's Latinos in the Law lecture. Thank you, of course, to my alma mater for hosting. I was mentioning to some of the students beforehand that I went to law school here in the last century, and we didn't have this building, we didn't have this venue. It's always nice to take it as one's own and use it for good things. So congratulations for that. And again, thank you to my alma mater. Thank you to everyone who has worked to make this event possible, and all of you for turning out today. Thank you to those who have been working on the setup and who will be working the reception immediately following. Thank you again for all of that. So I'm pleased to talk to you, even though it's brief, now I'll call it this evening, about a topic that has been a significant part of my professional work and that continues to be what I think timely, most especially in this election year, as the country is now focused on who will be the next president and how that president will best represent all the members of our diverse communities. And as we observe the discussions of how demographics will impact that election, it strikes me as an opportune time to consider the profound impact Latinos have had on our democracy, with a particular eye on how the law, on how the interests of the Latino community have impacted on our laws and our legal system, and how the legal system has shaped and defined the experiences of Latinos living in the United States. I can't do any talk, frankly, without talking about demographics. And that is because so often discussions about Latinos and how Latinos affect our world turns on the numbers, linguistic and gender characteristics, economic status, and housing and employment statistics about Latinos. How much is made of the large number and increasing size of the Latino population is always quite amazing to me. For those of you who have not been looking at the numbers during this election cycle, according to recent census data, Latinos constitute about 17 or 18% of the US population, about 54 million people, with an additional 3.7 million residents of Puerto Rico. Some data forecast that by 2016, Latinos will constitute 31% of the US population. That's almost 1 in 3, and does give slightly a new meaning to the movie title Los Tres Amigos. So just think about that. If that guesstimation turns out to be accurate, and Latinos in turn register and vote, then Latinos will be the group most likely to affect every aspect of modern day life, and the group most likely to set policy for the wealthiest country and most geopolitically impactful nation in the world. Whether Latinos are the decision makers or not, the issues concerning the Latino community, however, will be priority policy. You heard it here first. Let's hope I'm right. Returning to the numbers, here in New York, of course, the state has always been home to a vital Latino population and the site of significant migrant and immigrant shifts. Today, 18% of New York State's population, over 3.4 million, is Latino. And almost 29% of New York City's population, over 2.3 million, are of Hispanic origin. One interesting statistic about the Latino population, specific to the Puerto Rican community, is that there are now more Puerto Ricans living in the States and in the District of Columbia than on the island of Puerto Rico. In fact, almost 5 million Latinos of Puerto Rican origin live stateside, concentrated in the Northeast. The majority do still live in New York State, although there's some demographic shift happening there. And the majority of those live in New York City and in Bronx County. Some additional interesting facts about the Puerto Rican migration is that 31% of moves from Puerto Rico to the mainland, what we call the mainland, and 20% of moves from one state to another were to New York. Of course, the recent economic crisis in Puerto Rico has hastened the migration from that island to the United States overall, and certainly to the island of Manhattan. I tried to look up the most recent data for you, and if you give me a moment, according to the Pew Research Center, U.S. Census Bureau data shows that 144,000 more people left the island of Puerto Rico for the mainland than the other way around from mid-2010 to 2013. A larger gap between immigrants and migrants than during the entire decades of 1970s, 80s, or 90s. And of course, as I've mentioned before, since I referenced the economic crisis, but overall, as is true for most people who either immigrate, or migrate to the United States, the search for economic opportunity is the most commonly given explanation for moving from the island of Puerto Rico to the mainland from 2006 to 2013, and it is true even today. I believe the numbers, if you give me 1 second, I think we're at about, 3,000 people a month or something like this who leave the island of Puerto Rico. It is a tremendously large number of people coming here trying to escape a dire situation. Most particularly, I think, problematic given that we're talking about citizens moving from one space to another of the United States. The Latino diaspora in New York State is quite dynamic, as you may be aware. It includes several other subgroups beyond Puerto Rican, so you don't think I'm Puerto Rican-centric. I am Puerto Rican, but not Puerto Rican-centric for purposes of the talk. The majority of these subgroups call the Big Apple home. According to what I would say are conservative figures, over 700,000 Dominicans. How many Dominicans? Any Dominicans? All right, so you won't have to correct my numbers, very good. And over 300,000 Mexicans. All right, there we go. Live in New York City, perhaps around the block or in this building, who knows, as well as over 200,000 Ecuatorianos in the room. All right, there we go. Thank you. 98,000 Colombianos in the room. Okay, well, there you go. And to round it off, approximately 388,000 people identify as a member of another Latino subgroup. So we are quite the diaspora here. So even though the census numbers have been criticized for undercounting that population, they do give us, I think, a sense of the increasing presence of Latinos in the United States, in New York, and as I've only just learned in this law school, which to my great surprise and pleasure has apparently many more Latinos attending than I had ever thought. In my own class, there were only about 12. As I said, I graduated the last century, but not that far away. And apparently there's 3 years worth of what I experienced at law school in 1 year here. So on the tape, for the record, kudos and congratulations to the law school for doing something that when I went to law school they said was impossible. But I'm glad to hear that the dean, the faculty, and the administration and the communities did indeed find a way. Now, for some people, Latino history begins and ends with Hispanic Heritage Month, the mid-September to mid-October celebration of all things Hispano, or at least the most uplifting parts of the story of Latinos in the United States. However, the history of Latinos has its roots centuries before the 1968 launch of Hispanic Heritage Month. Indeed, some Latinos can trace their family origins on what is now U.S. land and territory back to a time predating the establishment of the United States that we know today. For example, what is now Texas and California, using the name of the time, was of course home to the ancestors of many Hispanic families. And there are Latino descendants of Native American peoples who were present in Latin America and the Caribbean long before European settlers. So indeed, we have quite the history with the U.S. We know from even a cursory review of that long history that Latinos then and now have advocated vigorously for equal treatment under the law. In more recent times, those struggles for justice have shaped the lives and made possible the professional careers of Latinos living in today's ever-changing world, including myself and I have no doubt many others in this room, in this law school, and on the island of Manhattan. I am constantly amazed at the fact that not so long ago, those who are the parents and grandparents, if not great-grandparents, of today's U.S. Latinos came here looking for something better, perhaps without a working knowledge of English, and perhaps after enduring a physically demanding trip or after leaving everything they knew and owned behind. What strength of character, what tenacity, what courage to take such a bold step to a place unfamiliar and, as a matter of historical fact, one so often uninviting, especially at a time when travel was not as easy and comfortable as it is today. Just stop for one moment and think of how far the families of those pioneers have come in just 1 or 2 generations. I use myself as an example. My mother did not get past the 5th grade, came here and worked in factories her whole life, and her daughter is a member of the highest court of New York. You don't get that in many other places, and we are very, very grateful and recognize those accomplishments. But although there has been much positive change, and we need to celebrate it and recognize it and champion it, many of the struggles and challenges faced by those who came here looking for safety and opportunity continue today. Contrasted with so many stories of achievement, there is the reality that large numbers of Latinos lead lives of great economic difficulty and do not share equally in the great opportunities of this country. Many of them, again, may be relatives of people in this room, may be working in this building, may be cleaning your space when you leave the rarefied world of the law school to go sleep in a nice, comfortable bed. The data on Latinos in the United States reminds us that there is much work to be done. Take education, the great leveler of inequality. So many of us know firsthand that a quality education can place an individual on the course towards success. Many Latinos, however, face challenges that result in lower rates of educational attainment. For example, although the Latino national high school graduation rate has increased over the last decade and now hovers around 76%, it continues to be lower than the approximate 85% rate for whites. In New York State, the Latino rate is even lower at about 62%, approximately 15 points lower than the overall state high school graduation rate. Latino college graduation rates are also lower at a mere 41%. I need only remind this group that law school numbers are increasingly low, even though you've got some good numbers at this law school. 5% of Latinos attend law school, just 5%, so you are in a very, very elite category, not only because you're at a great law school. These numbers have translated, of course, to underrepresentation within the legal profession. A mere 4% of all U.S. lawyers are Latinos, even fewer women, you mentioned Latinas. Even in that category, less than 2% of Latino lawyers are women. Only 4.5% of judges, magistrates, and judicial workers are Latino. And in my former life, before joining our Court of Appeals, as an academic teaching at CUNY School of Law, and I know there's at least one CUNY alum here, yay, yay, I was one of only 3% of law professors who are Latino. Those numbers are changing. Certainly when I went to law school, I didn't know of any law school dean who was Latino, and now there are indeed a small number of those who fit into that category. Whether our profession provides opportunity moving forward will be part of your work and your challenges. So it's just my little plug for you to keep changing the law school and ensuring that people like yourselves have the opportunity to do the great work that lawyers get to do every day. But even though Latinos are underrepresented in the legal profession, the impact of their work is by no means inconsequential. Indeed, Latinos have litigated and participated as litigants and advocates in many important cases in a variety of substantive areas. So for those of you who have not taken a Latinos in the Law course, and let me just ask, I forgot to ask that before, does NYU have a Latinos in the Law course? All right, so we'll all get educated tonight. So for those of you who may, however, have knowledge of the jurisprudential history of Latino issues, you may find some of what I am about to say familiar. For those who do not recognize the cases I'm about to briefly, and I do say briefly because of the time that's allotted, I don't want to suggest in any way that the history of the struggle for Latino civil rights can be condensed to the few moments we have tonight. I'm just going to give you a little bit of a taste, if you will, en sabor, as they say, of what the struggle has meant and what some of these cases are. But I do, again, hope, and I encourage you, that during the many hours of downtime that a law student is apt to have, and I know you have a few moments, that you look up the cases, read how the courts have responded to the claims of Latino litigants, and if you really want to dig deep and find the time to do so, I encourage you to read the briefs that were filed with the courts. This will allow you to hear how Latinos and their lawyers and their advocates described their lives and their struggles, hear their own voices. I am positive that I am unable to do justice to those descriptions of those lives and those struggles today, but I hope that I will at least pique your interest to learn more. So since we're in a law school, I thought a good place to begin the review of these cases was with the 1954 Hernandez v. Texas Supreme Court case written by Justice Warren, which extended equal protection under the 14th Amendment to Mexican Americans on the basis of ethnicity. In Hernandez, the petitioner argued that persons of Mexican descent were systematically excluded from jury service. The court rejected Texas's argument that the 14th Amendment was inapplicable because it only prevented segregation based on race. The court declared that while race and color have defined identifiable groups that at times have needed aid from the courts to secure equal treatment, community prejudices are not static, and from time to time, other differences from the community norm may define other groups which need the same protection. When the existence of a distinct class is demonstrated, and it is further shown that the laws, as written or as applied, single out that class for different treatment, not based on some reasonable classification, the guarantees of the Constitution have been violated. One way to establish that Mexicans are a distinct class from whites, the court held, is by showing the attitude of the community. Obviously, the court was not referring to the Mexican community, but we'll just stay with this for one moment. The court went on to recognize that the evidence in the case established that, again, that community distinguished between white and Mexican, as demonstrated by the limited number of Mexicans in business and community groups, the fact that Mexican children until recently had attended segregated schools, what were known as the Mexican schools. A restaurant bore a sign, "No Mexicans served," and on the courthouse grounds, during the very proceeding discussed by the court, 2 men's toilets could be found, one unmarked and the other marked, "Colored men and hombres aquí," Spanish, of course, for men here. Given that despite the significant population of Mexicans and that no one had served on the jury in the country, the court concluded, in the county, the court concluded that the petitioner had carried his burden of proof to establish discrimination, which the state of Texas failed to overcome. And that case was argued by a team of Latino lawyers from Texas. Very impressive, considering the time frame and the issues before them. Now, there are 2 numerous voting rights cases for me to discuss, many filed by Latino Justice PRLDEF and MALDEF, and I know the President and General Counsel of MALDEF did this talk a couple of years ago, and I know of the great work that both of those institutions do. But there are just too many cases. But in those cases, Latinos advocated for both access to the ballot as well as a meaningful opportunity to select a candidate that represents their concerns. There are the cases involving access to bilingual ballots, which were about participation in the political process by those for whom English presented a challenge to exercising the franchise. And I'll turn to that shortly. So I'm going to mention briefly a case of particular significance and one that comes from New York, so a homegrown case, which I thought might be of interest to you. In Katzenbach v. Morgan, which hopefully is familiar to you, it's a major constitutional case. Yes, no, maybe so, hands up? Okay, so not completely unfamiliar, good. Decided in 1966, Justice Brennan wrote for the majority, upholding congressional authority under Section 5 of the 14th Amendment to enact laws to enforce the Constitution. The law at issue was the Voting Rights Act. very critical statute, and one, of course, in an election year that everyone is focused on, but you should be focused on it all the time. But the specific provision at issue in the case was Section 4E, which prohibited English literacy tests as applied to New York City residents from Puerto Rico. Yes, citizens were subject to English literacy tests. The provision was critical to Puerto Ricans who had relocated from Puerto Rico to the United States because in New York, English language requirements and literacy tests have been used to deny the right to vote to Puerto Ricans who are, by law, citizens of the United States. The court held that the law itself referred to persons who have migrated from the Commonwealth of Puerto Rico to New York and who have been denied the right to vote because of their inability to read and write English, and the 14th Amendment rights referred to include those emanating from the Equal Protection Clause. More specifically, Section 4E may be viewed as a measure to secure for the Puerto Rican community, so he got it right, the community there, reading in New York, non-discriminatory treatment by government, residing in New York, both in the imposition of voting qualifications and the provision or administration of governmental services, such as public schools, public housing, and law enforcement. Section 4E may be readily seen, the court said, as plainly adapted to furthering these aims of the Equal Protection Clause. The practical effect of Section 4E is to prohibit New York State from denying the right to vote to large segments of its Puerto Rican community. Congress has thus prohibited the state from denying to that community the right that is preservative of all rights. This enhanced political power, the court went on to say, will be helpful in gaining non-discriminatory treatment in public services for the entire Puerto Rican community. Section 4E thereby enables the Puerto Rican minority better to obtain perfect, I love the word, perfect equality of civil rights and the equal protection of the laws. It was well within, the court went on to say, congressional authority to say that this need of the Puerto Rican minority for the vote warranted federal intrusion upon any state interest served by the English literacy requirement. It was for Congress, as the branch that made this judgment, to assess and weigh the various conflicting considerations, the risk or pervasiveness of the discrimination in governmental services, the effectiveness of eliminating the state restriction on the right to vote as a means of dealing with the evil, the adequacy or availability of alternative remedies, and the nature and significance of the state interests that would be affected by the nullification of the English literacy requirement as applied to residents who have successfully completed the 6th grade in a Puerto Rican school. So the court understood at that point the connection between equality and justice and the ballot and the right to vote. That case was argued by Puerto Rico's Attorney General against New York's Attorney General, quite the lineup. The New York AG, of course, represented registered voters, obviously not Puerto Rican, registered New York voters who sought to strike down this portion of the Voting Rights Act. Now imagine if the case had gone the other way, potentially no bilingual ballots, the continuation of these literacy tests, but also the power of Congress to address the problems faced, not just by Puerto Ricans and not just by Latinos, but everyone. That power would have been, of course, read increasingly narrowly. There are also the education rights cases, if I can move on, which illustrate how Latinos fought for the end of segregated schools and school districts. I hope you are familiar with Plyler v. Doe. Yes? I like to see the nodding heads up and down, not sideways. Decided in 1982 and authored again by Justice Brennan. I'm not Brennan-centric, but it's just the way it is. In that case, a Texas statute barred undocumented children from receiving any state funds for their education and authorized local school districts to deny them enrollment. In Plyler, a class of 4 families with school-aged children of Mexican origin who lived in Smith County, Texas, have been told by the school district that they would have to pay $1,000 annual tuition to attend the public school in Tyler Independent School District. The class sued, claiming that the statute violated the Equal Protection Clause of the 14th Amendment. The court agreed, holding that the 14th Amendment's protection extends to anyone, citizen or stranger, who is subject to the laws of a state and reaches into every corner of a state's territory. Further, it found that the status of undocumented children did not create a rational basis to deny them the benefits provided to other children residents of the state. And a MALDEF attorney filed the cases on behalf of the plaintiffs in that particular case. And if you think that some of what I'm talking about is just history, as I recall, the state AG just recently ended up settling an action for some school districts in Long Island who were doing the exact same thing I have just described was happening in Texas. So indeed, these cases are very timely, and the issues, unfortunately, continue to resonate with us today. Now, one of the most significant pre-Brown desegregation cases successfully challenged the separate education of Latino children in Orange County, California, eventually leading to the end of segregation of Mexican American and other Latino children in the Ninth Circuit. I hope you are familiar with Hernandez v. Westminster School District. Yes? Not so much. Well, we had a postage stamp with that case on it, so it's very discouraging that you don't know that case. Okay. This one you do have to look up if you don't want to look up any other case. It's a very fun read. In Mendez, the plaintiffs, Latino parents, argued on behalf of their children that separate but equal elementary school, remember this is pre-Brown v. Board of Ed, separate but equal elementary school facilities were unconstitutional as a violation of the federal 14th Amendment Equal Protection Clause. In the 1946 District Court opinion, the court stated that equal protection of the laws pertaining to the public school system is not provided by furnishing in separate schools the same technical facilities, textbooks, and courses of instruction to children of Mexican ancestry that are available to the other public school children regardless of their ancestry. A paramount requisite in the American system of public education is social equality. It must be open to all children by unified school association regardless of lineage. That may sound somewhat familiar to you, but that was said by a district court in 1946. When the school authorities appealed, not listening to their better half, they appealed to the Ninth Circuit. Thurgood Marshall and Robert Carter appeared as amicus on behalf of the parents and children. The families prevailed, but it was not until Brown v. Board of Ed that the U.S. Supreme Court held as unconstitutional the separate but equal doctrine and outlawed its application throughout the United States. So again, I do recommend that you read a case that's pre-Brown that will resonate with the pre-Brown approach to the post-Brown and Brown approach to these issues. Now, during the course of the past 60 years, Latinos have continued to advocate for quality educational experiences that result in measurable improved opportunities and life experiences. In addition to continued litigation efforts to end segregation of Latino students, lawyers and other advocates sought to establish equal access to education for immigrant students, again, Plyler v. Doe and other cases, adequate financing for schools with majority Latinos, hiring of competent and experienced teachers, as well as increased access to advancement programs and the types of educational resources previously available disproportionately to white students. And I'm just going to take a moment to discuss a couple of these cases because I think they may be of interest to you. In New York, again, we are well familiar, or at least perhaps some of us are well familiar, with our series of school financing cases. In 1995, our High Court, the Court of Appeals, reiterated its holding from Board of Education, Levittown Union Free School District v. Nyquist, that under the New York Constitution, the state had to offer all children the opportunity to have what the court called a sound basic education. Now, the plaintiffs in the case before the court were the Campaign for Fiscal Equity, Inc., a nonprofit organization consisting of community school boards, individuals, and parent advocacy organizations, 14 New York City school districts, individual New York City public school students, and their parents. The plaintiffs challenged funding for New York City schools under Article 11 of the New York Constitution and federal Title VI regulations. The court found that the state was failing to fulfill its constitutionally mandated responsibility under the state's Article 9, and ordered the state to address educational inadequacies, in New York City. Now, since that time, there's been continued litigation as to what that would mean, but it has also meant that our state legislature has had to provide more funding for the schools. So again, a case that had really significant impact throughout New York. Again, so that you don't think me still New York-centric, let me comment on the 1981 case filed by the Education Law Center in the Superior Court in New Jersey, just a few miles away, on behalf of a plaintiff class of 20 public school students from Camden, East Orange, Irvington, and Jersey City. Anybody live in any of those cities? Anybody know any of those cities? Well, I lived in Irvington, and I've been to Camden, and I've been to Jersey City. So it's a good thing they filed a suit, because the school districts were in great need. The suit alleged that the state's funding for public education was unconstitutional, as it varied significantly between poor urban and wealthy suburban districts, and that the funding provided to the urban districts was insufficient to meet the educational needs of those students. The New Jersey Supreme Court sent the case to an administrative law judge for an administrative hearing, and in the subsequent rulings, they created a comprehensive set of requirements for the New York school districts, including adequate funding for kindergarten through 12th grade, universal preschool for 3 and 4-year-olds, supplemental or at-risk programs, and curriculum and instruction reform. Now, I happen to have lived in New Jersey more or less around this time, and I know that the implications of that case, the idea that low-income school districts should get additional funding, and that some of that funding should come out of the pockets, if you will, of the wealthiest school districts, ended up, at a minimum, resulting in a governor losing a second term in office. So the politics and the education and the voting rights are all interconnected. And of course, as I mentioned, there are the cases involving bilingual education, where advocates sought to ensure that Latino students and other students, especially immigrant students, would not fall behind in school. In New York, again, we have our famous Aspida consent decree. Familiar with the Aspida consent decree? Oh, I feel very old. Or you are very deprived. I hope it's the latter. In New York, the Aspida of New York case, filed in the federal courts, argued that argued that in order to provide linguistically appropriate instruction for in that case it were Puerto Rican students, and the failure to do so was a deprivation of the rights of those students under the 14th Amendment and the Department of Education regulations. The litigation eventually settled, which is why I refer to the Aspida consent decree, and established that 1974 settlement agreement, the consent decree, which has been the foundation of bilingual education in New York for decades. The decree, indeed, was a key factor in bilingual education spreading throughout the city's school system and even to other parts of the country. There were other cases, including Lopez de Vega v. Thomas, a bilingual education suit filed against the city of Philadelphia. Anybody from Philadelphia? Anybody know Philadelphia? Heard of Philadelphia? Heard of Pennsylvania? All right. That case was settled in 1977, and the Philly School Board subsequently formally adopted an equal educational opportunity statement. Other jurisdictions were also sued to create bilingual education programs to address the language needs of Latino students in Patchogue, Long Island. How about that one? All right. You've heard of Long Island, though. You're making me crazy. Central Islip, Long Island. Oh, this is very sad. Someone needs a map. Vocational education programs were also made available to Spanish-speaking school students throughout Connecticut. We've heard of Connecticut? Very good. All right. But you get the point. There indeed was this movement to ensure that students, what that time were called limited English proficient students, they're English language learners today, would indeed have an opportunity to succeed equally in school if given appropriate linguistic educational services. So, where are Latino students today, if I can just digress for a moment? What's the state of educational access for Latinos? To answer those questions, we begin with the significant demographic changes since, I mentioned Brown, and it's the one case every law student knows, Brown v. Board of Ed. Over the more than 60 years since that case, but most recently in the last 2 decades, Latinos have become, as I've already mentioned, a large population, but a large percentage of the school-age population, which you, of course, may have already noticed, and may count yourself as part of that. 1 in 4 public school students in 2012 was Latino. 1 in 4, imagine that. With a markedly large number of younger students. 27% of kindergarten students are Latino. 25% of elementary school students and 23% of high school students are Latino. Don't they tell you in law school, look to your left, look to your right, somebody's gone one day or another, look to your left, look to your right, somebody else is Latino. That's the way it goes today. But despite the increase in numbers and the geographic dispersion of Latinos, the majority of Latino students attend public schools in highly segregated educational settings, which helps you to understand why that struggle for desegregation really has meaning. Today, a Latino student attends a school that is 57% Latino and 25% African American, meaning a school which looks very much, if not more so, like the schools pre-Brown. In fact, schools are more segregated today than they were before Brown v. Board of Ed was decided. That is not to say, please, don't misunderstand me, that Latino students and students of color cannot learn in a school that is majority Black or Latino. That is not the point at all. The point is, what do those schools look like? What are the offerings and opportunities provided to students when they are in a segregated environment? And I would say the other point that's often lost in the discussion about Brown, because we're focused on the numbers and the books and the finances and all of that, is that it means white students do not interact with a person of color until they are adults. And many of their ideas of who a Latino is, who an African American is, has already been shaped. And you and I are working against, perhaps, some very negative stereotypes by that point. The data indicates that Latino and African American students attend schools with a high concentration of low-income students. According to one report, half of students in 91 to 100% Black and Latino schools are in schools that also have more than 90% low-income students. The report goes on to state that these students face almost total isolation, not only from white and Asian students, but also from their middle-class peers. As the study shows, there is a high correlation between racial and economic school segregation. Segregation based on income leads, of course, to increased disparities in access to educational resources and affects school outcomes. Regardless of the causes, the data tells us that we have yet to achieve the goal of Brown and even Hernandez, Plyler, any of those cases, not just in terms of integration, but of educational opportunities and success. For example, while the Latino high school dropout rate, again, is decreasing, it remains high at approximately 4% compared to 5% for whites, and I've already gone through some of those numbers. Brown and the Civil Rights Act, of course, represent judicial and legislative efforts to ensure the guarantee of equality, despite this history that I've already described, and I'm going to describe a little bit more in a moment, of resistance to integration. Communities continue to challenge obstacles to equality and justice, which has always been at the heart of the political and legal movement for educational access and the heart of the Latino struggle for civil rights. Those efforts remain the inspiring legacy of Brown, Plyler, Hernandez, Katzenbach, you name it, any of those cases. This is the legacy. Now, other civil rights cases that I don't really have time to go into any great detail on sought to end discrimination in housing and employment, and those of you who are particularly interested in those areas, my apologies that I can't do really a survey of those cases. And of course, there are the cases that in con law you're often more familiar with that discuss public accommodations, desegregation, and so forth in restaurants, theaters, parks, and pools. There are the cases where Latinos sought to end discrimination in healthcare services. That has been since time immemorial, although people think of it, of course, more recent given the Affordable Care Act and the struggles for access to quality healthcare services. But of course, for Puerto Ricans, we're well aware of sterilization abuse, as are many other women of color in this country. So there is a long history dealing with reproductive rights and healthcare services for Latinos and Latinas. There are the cases regarding environmental justice, and I believe that a prior speaker did indeed address environmental justice and the Latino community. There are the cases for free exercise of religion. There are cases arguing about the fair and just treatment of Latinos regardless of immigration status. I talked about children, but these cases, of course, deal with immigrants across the board. And the cases seeking to ensure gender equality and equity for women in the Latino community. And of course, the recent efforts to address equality of Latinos who are members of the LGBTQ community. Those cases are part of the very, very robust Latino civil rights movement, and were made possible because of the efforts of so many Latino community advocates, including Latino lawyers, law students, and others who felt that there was something just wrong in the United States when you don't treat people fairly and justly. But I would be remiss if I did not comment on the overrepresentation of Latinos in the criminal justice system. Whether the victim, accused, or convicted, here is one part of the American experience with which too many Latinos are all too intimately familiar. Latino victims were over 28 per 1,000 individuals experiencing violent crime. Among all Latinos, 27% say that they or an immediate family member has reported a crime in the previous 5 years. According to a 2009 report by the Pew Hispanic Survey, in recent decades, Hispanics' exposure to all parts of the criminal justice system has risen even faster than their rising share of the U.S. adult population. The report relied on a 2008 nationwide survey of the Latino population, which found that nearly 23% of Latinos in the survey said that they or an immediate family member had been questioned by the police in the previous 5 years. Nearly 15% of Latinos say they or an immediate family member had been arrested in the previous 5 years. And over half, 56%, said they or an immediate family member had contact with the criminal justice system in the previous 5 years. I can't think of numbers sadder than that. That more than half the people who responded to this survey themselves or an immediate family, not just a friend, not someone they kind of know, an immediate family member had contact with the criminal justice system. Now, if you do not already know, contact with the criminal justice system does not usually mean a pleasant experience. People do not go into the criminal court unless they are employed there for a reason that we can say is life-affirming. The number of incarcerated Latinos remains high. Latinos represent 20% of the U.S. incarcerated population. In 2007, and my numbers are already beginning to be very outdated, as you can tell, but in 2007, 4% of adult Latinos, 4%, were in jail, prison, probation, or parole. 17% of Latinos say they or an immediate family member has been under some kind of criminal corrections control in the previous 5 years. I'm going to say that one again. 17% of Latinos say they or an immediate family member has been under some kind of criminal corrections control. It didn't say supervision, control, in the previous 5 years. Turning to perceptions of fairness, and as lawyers, judges, law professors, advocates, law students, it is not only, of course, the actual law, which always matters, but it is also the perception, the appearance, that is critical. Turning to the perception of fairness, of those surveyed, only 45%, the inverse of the more than half that have gone through this criminal justice system, only 45%, compared with 74% of whites and 37% of African Americans, so only 45% of Latinos, said that they are confident that police officers will treat Latinos fairly. And I cannot say whether that number has changed over the past years and months. Given the events across this country, I dare say that's unlikely. Nevertheless, assuming the numbers are unchanged, as a judge and as a member of the legal profession, I find it most disheartening that less than half of those Latinos surveyed believe that courts in their community will treat Latinos fairly. I continue to believe, however, that the numbers and these perceptions of our justice system can be changed during our lifetime. The struggle for Latino civil rights is about that kind of change. We should acknowledge that successes have come as a result of the work of pioneers who made their way to this country to find a better life and who too often faced discrimination and scorn. In spite of those challenges, they stayed because they believed that their children and grandchildren, and probably great-grandchildren, would live a better life. That life includes full participation in our democratic society. It means that their children, grandchildren, and grandchildren, great-grandchildren will be entitled to justice and fair treatment under the law. It is up to all of us, whether we are members of the legal profession or not, to ensure that that legacy is indeed fulfilled and remembered. Thank you again for inviting me tonight. I'm happy to do questions, yes, and answers for the few minutes we have before whatever you have going on in this reception. I don't know. I assume some beverage. Thank you.